My name is Michaela Askew,
And my name is Elizabeth Adeoye.
and we represent the petitioner, the Roxanne Torres.
We are arguing that Torres was seized under the Fourth Amendment because 1. At common law, a seizure does encompass an unsuccessful attempt at detaining a suspect.
2. When comparing false imprisonment to an unsuccessful arrest, there is a clear violation of the 14th Amendment.
And 3. The lower court's ruling is inconsistent with the ruling in California v. Hodari D.
Would the court benefit from a brief recitation of the facts?
Yes.
In 2014, New Mexico State police officers went to an apartment complex in Albuquerque to arrest a woman. The officers saw two individuals standing in front of the woman's apartment next to a Toyota Cruiser. One of the officers approached the cruiser's closed driver's side window and attempted to tell Torres to show her hands. According to Torres, she did not know that Williamson and Madrid were officers and in fact thought that she was being carjacked, which resulted in her stepping on the gas to get away.
The officers shot at Torres as soon as the cruiser moved a little bit. Two bullets shot Torres, however, she continued forward and was not detained until she was admitted to the hospital. In October 2016, Torres filed a civil rights complaint in federal court against the officers, claiming that the intentional discharge of force is exceeding the degree of force which a reasonable law enforcement officer would have applied. The court held that the officers were entitled to qualified immunity and was reasoned that the officers had not seized Torres and therefore no Fourth Amendment violation had occurred.
The Fourth Amendment protects the right of the people to be secure in their persons against unreasonable seizures. In evaluating the scope of these protections, the court in Wyoming v. Houghton found that it inquired first whether the action was regarded as an unlawful seizure or search under the common law when the amendment was first framed. And even before this approach was embraced, several courts were already describing the significance of this rule as shedding light on what the framers of the amendment might have thought to be reasonable. As Peyton v. New York states, the Fourth Amendment is to be constructed in light of what was deemed a reasonable search and seizure when it was adopted, and in what a manner which will conserve public interest as well as the interests and rights of individual citizens.
The Fourth Amendment refers to seizures of persons, and such language was used interchangeably with the term arrest when the Fourth Amendment was drafted and ratified. At that time, the meaning of arrest under the common law was clear, long established, and widely known in both England and America. And as held in California v. Hodari, under the common law rule, the application of physical force for the purpose of detaining someone constituted an arrest, regardless of whether or not the person eluded capture. These words, therefore, naturally had been understood by those who ratified the amendment as incorporating the concept of an arrest. Then, as now, an arrest was the four quintessential seizure of the person, as found in Carpenter v. United States, and by all accounts, the amendment is designed to shield the security of individuals against any arbitrary invasions by government officials.
The whole purpose of the framers adopting the Fourth Amendment was, in part, to protect the American people from unreasonable applications of physical force by government officers seeking to detain them. The framers viewed the ability to vindicate that right in court as a safeguard against the type of abusive government practices against which they revolt at the founding. Applying the common law's traditional definition of arrest to seizures of the person under the Fourth Amendment will simply facilitate the ability of people like Torres to present their claim in court, where the reasonableness of the police officer's decision to shoot may be properly assessed.
This is furthered in Hodges v. Marks, where the court found that both before and during the founding era, arrest occurred when the officers touched a person with the intent to arrest them, even if they did not immediately succeed in detaining them. In today's case, officers Williamson and Madrid acknowledged that they shot Torres in an attempt to stop her flight. Torres's subsequent flight is therefore analogous to escape at common law, and although only for a short time did she escape detainment, she was nevertheless arrested the moment the physical force was used against her.
Adapting the traditional common law rule to the contemporary policing context in the modern technological era does not distort the practical implications of that rule in a way that would undermine its appropriateness and relevance. To adhere to that will actually help to avoid a disparity that would otherwise result between the Fourth Amendment protections for property and its protections for a person's own human body.
What is a common law arrest?
A common law arrest is a mere grasping or application of physical force with lawful authority, regardless of whether or not it exceeded in subduing the arrestee. This is concluded in cases such as California v. Hodari, Tennessee v. Gardner, and Payton v. New York.
The analogous Fourth Amendment common law false imprisonment tort actually utilizes a similar analytical structure to the one used in California v. Hodari. Like a common law arrest, the common law false imprisonment distinguishes between restraint by fear and restraint by force. Specifically, a plaintiff asserting a common law claim of false imprisonment must demonstrate that the resistance of her personal liberty or freedom of movement resulted either from force or from fear. The tort protects the sacred right of every individual to the possession and control of their own person.
The linguistic formulations of the relevant Fourth Amendment and false imprisonment tests both focus on whether there has been a restraint on the person's personal liberty or freedom of movement. Marcus v. Ledman held that when a false imprisonment claim is instead based on restraint by fear, the court requires the plaintiff to prove more. Namely, the plaintiff submitted to imprisonment because of a reasonable fear that failing to do so would lead to the use of force. Cases dealing with false imprisonment typically examine whether the defendant's actions, words, and gestures put the plaintiff in fear of personal difficulty or personal injuries.
These requirements for restraint by fear are also consistent with this court's account of a Fourth Amendment seizure through a show of authority. As in the false imprisonment context, the species of seizure includes an additional objective element regarding a subject's submission to the officer's show of authority, and more particularly, whether a reasonable person would have believed that he was not free to leave. As stated in Hodari, quoting United States v. Mendenhall, this objective inquiry, too, looks to factors nearly identical to those examined in false imprisonment cases, including the threatening presence of several officers, the display of a weapon, some physical touching of the person to the citizen, and the use of language or tone of voice.
Based on these factors, it is almost irrefutable that the facts of today's case rise to the level of restraint by fear without even having to resort to restraint by force. Under the totality of the circumstances, having officers that were wearing tactical vests with police markings approach towards the vehicle, ordered Torres to show her hands and brandished discharged their weapons, and struck Torres with two bullets. Regardless of how Torres responded to each of these acts, it is conceivable that a reasonable person in her position would have feared personal injury or difficulty if she did not comply.
Hodari also divided the efforts by police officers to stop citizens into two distinct categories. One, those based on the applications of physical force to the individual's body, which are always seizures. And two, those based on a mere show of authority, such as an order to stop, which become a seizure only if the individual actually submits to the authority and stops. And as that court has already explained, an arrest either an arrest requires either physical force, or where physical force is absent, the submission to the assertion of authority with respect to the physical force, the court explained the word seizure readily bears the meaning of a laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful.
Hodari then made it clear that this intricate analysis is not necessary when an officer applies physical force in an attempt to apprehend a suspect. These common law on arrest leaves no doubt that in this scenario, a seizure has occurred. This mode of analysis has the additional benefit of simplifying straightforward cases as found in Florida v. Jardins. It is undisputable that an officer conducts a search when she physically intrudes on a private citizen's property to gather evidence. It should also be equally indisputable that an officer commits a seizure when she applies physical force to apprehend a suspect. Both of these actions infringe on the people's right to be secure in their persons, houses, papers, and effects. Just as a common law trespass qualifies as the Fourth Amendment seizure, so too should a common law arrest qualify as a Fourth Amendment seizure, as the court has already recognized?
Did California versus Hadari hold that the Fourth Amendment encompasses the common law definition of arrest?
Yes, Your Honor. The majority in California v. Hodari stated that the framers and their contemporaries understood the quintessential seizure of a person to be a common law arrest, and that the word seizure readily bears the meaning of a laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. The Tenth Circuit's requirement that such laying on of hands must successfully terminate the person's movement to trigger Fourth Amendment scrutiny is exactly the kind of, quote, rigid all or nothing model of justification and regulations that the quote in Terry v. Ohio warned would obscure the utility of limitations upon the scope as well as the initiation of police action as a means of constitutional regulation.
That court's rule also depends not only on the officer's own actions or decisions, nor on the subject's actions prior to the use of force, but on the reaction of the subject to the officer's use of force. However, the court in Hadari drew a line of cleavage between situations involving physical force and those involving a show of authority. It held that where the police did not physically touch a suspect, there is an additional requirement to establish that a seizure occurred. The suspect must have actually submitted to the officer's show of authority.
Under the original meaning of the Fourth Amendment and the common law, although the application of a physical force in an attempt to restrain Roxanne Torres was unsuccessful, it does constitute a seizure under the Fourth Amendment because if the slightest application of a physical force is enough to effect an arrest, then the use of deadly force must certainly be a Fourth Amendment seizure, as stated in Tennessee v. Garner. Under Hodari D, at common law, a seizure does encompass an arrest, that it applies physical force. This court stated that, quote, the mere grasping or application of physical force with intent to restrain constituted an arrest, the quintessential seizure of the person, whether or not it succeeded in subduing the arrestee. When comparing a common law arrest to false imprisonment, it is clear that in this circumstance, a seizure has occurred.
To uphold the Tenth Circuit Court's ruling does little to advance the interests often described as underlying the Fourth Amendment. Unless this court applies the common law's broad definition of arrest, law enforcement officers who lack a justification will be able to shoot or otherwise physically harm individuals with no constitutional accountability so long as those individuals successfully escape the officer's violence. To rule in favor of the respondent would significantly weaken the Fourth Amendment's value in protecting individual liberty from unjustified government intrusions. It is for these reasons we pray that the court will in favor of the petitioner, Roxanne Torres, and reverse the lower court ruling.